If you are ready then, Advocate Hodges, you may proceed.
Yes, Your Worship.
As previously alluded to, I did in fact compile written heads of argument. I've handed copies of my heads of argument to my respective learned friends, and I have the signed original that I beg you to hand to Your Worship. I ended up with.
Thank you. Thank you. Thank you. Then you may proceed.
Thank you, Bishop. I'll be reading from the heads of argument and referring to respective items when I get to them. But the heads of argument are as follows. In the Regional Division of the Eastern Cape, held at East London, case number RC 446/2020, in the matter between the state and Julius Malema, accused 1, and Gerhardus Adriaan Snyman, accused 2. Heads of argument on behalf of accused 1 in support of an application in terms of section 174 of the Criminal Procedure Act 51 of 1977 for his discharge. Introduction. 1. The accused are arraigned on 6 counts. Accused 1 faces 5 of the counts and accused 2 faces only 2 of the counts. The counts all relate to an incident at the Sisa Dukashi Stadium at Ndatani, and then we refer to that thereafter as the stadium, within this Honourable Court's jurisdiction, on 28 July 2018, when the EFF celebrated its 5th anniversary. We refer to this as the celebration. 2. The charges are that, sub 1, accused 1 unlawfully possessed a firearm, to wit a .223 Norinco rifle, and or a firearm the make of which is unknown to the state, without holding a license, permit or authorization. Sub 2, accused 1 unlawfully possessed ammunition, to wit a .223 Remington bullet, without holding a license, permit, a dealer's license, manufacturer's license, gunsmith's license, import or export or in transit permit or authorization to do so. Sub 3, accused 1 unlawfully discharged a firearm, to wit a .223 Norinco rifle, and or a firearm the make of which is unknown to the state, in a built-up area, in a public place, to wit the stadium. Sub 4, accused 1 and 2 unlawfully failed to take reasonable precautions to avoid danger to personal property, in that the accused both had control of a loaded firearm, to wit a .223 Norinco rifle, and or a firearm the make of which is unknown to the state, in circumstances where it created a risk to the safety or property of the general public attending the celebration. Sub 5, accused 1 recklessly endangered a personal property, in that accused 1 unlawfully discharged or handled a firearm, to wit a .223 Norinco rifle, and or a firearm the make of which is unknown to the state, in a manner likely to injure or endanger the safety or property of the general public attending the celebration, residents of Mdantsane and employees of Gear House, or with reckless disregard for the safety or property of the general public attending the celebration, the residents of Mdantsane and Gear House employees. And sub 6, accused 2 provided a firearm or ammunition to any person not allowed to possess it. Now, Worship, to explain further in this regard, to reach the end of the state's case and not know whether it was a Norinco .223 or a Remington .223 or the firearm or ammunition, the make of which is unknown to the state, at the end of the state's case, speaks in itself volumes with respect. Paragraph 3. The accused both pleaded not guilty to the respective charges levelled against them. Accused 1 denied the allegations against him, put the state to the proof thereof. Accused 2 gave a detailed plea explanation. The evidence. 4. The state led the evidence of the following 19 witnesses. Ngamlani Nkwali, who was in charge of the celebration. Tomifikile Mankuma, a cleaner who found the spent cartridge whilst cleaning the stadium after the celebration. Mfundo Avri Azili Cristiano Ngwangwa, the supervisor of the aforementioned cleaner. Gerhardus Johannes Swart, who received and sealed the spent cartridge. Jonathan Kumala, the Assistant Manager of Disaster Management, who took photos of the scene. S.H. Stander, the Regional Manager, Eastern Cape of the Private Security Industry Regulating Authority, hereinafter referred to as CIRA. Lieutenant Colonel D.J. Janssen of the Provincial Firearm, Liquor and Second-Hand Goods Section, Flash, within the SAPS in that region. Sergeant Pierre Becker, scene of crime witness from the SAPS. Colonel Magwadleka, also from the ballistics section of the SAPS, who tried to link the spent cartridge to a particular firearm and compiled 10 statements, who were subsequently recalled by the magistrate to clarify certain aspects of his testimony. Sibusiso, Professor Mkobo of Gearhouse, Ashley Singh of Gearhouse, Samuel Ntanzo Kwato of Gearhouse, Captain Mokosiko, Vincent Mzuku, the Cluster Communication Officer of the SAPS East London, Eastern Cape, Dwayne Frederick Francis, who conducted the digital forensic investigation of video footage, Captain Sorrel Jacobus Kruger, who received 3 batches of firearms, Warrant Officer Mandy von Steenkamp, a qualified facial identification specialist, to analyze still photos from video footage and identify the accused 1 and accused 2, Captain Rian Buerta, a cyber forensic investigator, to analyze video footage and compiled a report comparing hashtag values and identified the accused 1 and 2 but not the firearm. Captain Mona Sandari, Governor, the retired former media center controller and media spokesperson of the SAPS, and Colonel Rodney Stephen Swartboy, the investigating officer, deposed to 23 statements but could not say whether the firearm seen in the video footage was a real firearm or a stage or blank firearm. Notably, the state was permitted to play video footage that had been spread on social media and had gone viral, hereinafter referred to as the viral footage, as well as the video footage that had been recorded by the above detailed employees of Gearhouse, hereinafter referred to as the Gearhouse footage. The viral footage depicted the shooting, but the Gearhouse footage did not. These were accepted as exhibit by this Honourable Court. It subsequently became apparent from cross-examination that the authenticity of the viral footage had not been established, and the laptop on which the original Gearhouse footage had been captured had been stolen. Due to time constraints and limited resources available when these written heads of argument were compiled, the final details of this evidence, lead-in-chief, cross-examination and re-examination accepted as exhibits by this Honourable Court, will be highlighted in greater detail during oral argument. So if we turn, Your Worship, to the exhibits as read with the evidence, Your Worship is aware of the A series of exhibits that details the scene of the celebration, after the celebration, and shows exactly, Your Worship, where the stage had been set up, what it comprised of, and the structures that were on site at the time. And this will be the basis, Your Worship, of the argument that it would be impossible, and at the very least highly improbable and highly unlikely, but we say impossible, for the spent cartridge to have been found where it was found if it had been fired at the celebration in the circumstances depicted in the video footage that the court has seen. Notably, Your Worship, and you will hear it through the heads of argument, no eyewitness was called, no person who attended the scene who feared for their life or feared that they'd shoot was called. If one takes the example, Your Worship, and that will be the argument, if someone took out a firearm now and started shooting before this Honourable Court, everybody would duck for cover. You do not, with respect, see that on the video at any particular stage, Your Worship, which would go against the state having proved sufficient evidence to put the accused on his defence, or put different in terms of 174, having been given a reasonable opportunity to do so, is not adduced evidence to satisfy this Honourable Court that a court acting reasonably could convict. The clearest indication of that, Your Worship, ironically, because of the way that I'm going to address, Your Worship, will appear from Exhibit A3, Photo 8, Your Worship, where the witness points out precisely where she found the spent cartridge, which, if one has regard to Exhibit A being the photograph of the stage, Your Worship, is impossible. Your Worship, one can also have regard to the further cross-examination of the witnesses called by the state and the concessions that they made, but at the end of the day, Your Worship, there is no person that has come before this Honourable Court to say, I attended that event, I feared for my life, I'm an eyewitness, there were shots fired, the following damage has been caused. Had a bullet struck me, it would have caused damage. Had a real firearm been fired in my presence, there would have been damages and injuries, or there was a very reasonable chance of this occurring. This is not, with respect, occurred here. This is borne out, Your Worship, by all of the evidence before this Honourable Court, and will be the basis of the argument in support of the discharge of accused number 1. So if we turn then, Your Worship, to the submissions, we say at the end of the state's case it became apparent inter alia that, firstly, not one of the many eyewitnesses to the celebration complained of any firearm being discharged. Secondly, not one of the many eyewitnesses to the celebration complained of any fear or danger due to a firearm being discharged. Thirdly, not one of the many eyewitnesses to the celebration had run for cover during the celebration in fear for their life or property. Fourthly, in fact, and most startlingly, not one attendee from the many people who had attended the celebration was called to testify as an eyewitness. Fifthly, additionally, there had been 5 SAPS VIP Protection Services members on the stage at the celebration in the stadium, and not one of them had seen or complained of any firearm being discharged. Sixthly, these 5 SAPS VIP Protection Services members had been traced and had made statements, but none of them had mentioned anything untoward having happened at the celebration at the stadium. Seventhly, the place where the spent cartridge had been found would have been beneath structures that had been there at the time of the celebration, which made it impossible for it to have been fired from a firearm during the celebration, unless they had been penetrated and damaged, and they had not. Eighthly, it was not possible to say when the spent cartridge had been placed there. Ninthly, it was not possible for the spent cartridge to have been ejected from the firearm on the stage at the celebration and land where it was found. And tenthly, there was no touch, DNA traces or fingerprints to link accused 1 to the suspected firearm or the spent cartridge. So what we are saying, Your Worship, is that at this stage it would appear that the state's case is not improbable but absolutely impossible, and there is no witness that came before Your Worship and said, standing on the stage, when I fire a firearm of any caliber and it's ejected, and the spent cartridge is ejected to land in the vicinity of where this spent cartridge was found. It's just not possible. Secondly, Your Worship, there is no damage whatsoever to anything, as is going to become more clear and more apparent from the heads of argument as I proceed. Paragraph 8. The clearest indication of the deficiencies in the state's case were evident from the testimony of the investigating officer, Colonel Swartboy, who had fully investigated every aspect of this matter, been in charge of the investigation, deposed to 23 statements, and testified in chief inter alia that. And we're going to detail, Your Worship, of his evidence, because he in essence summed up the entire case for the state. Firstly, he had been assigned to investigate the alleged shooting at the celebration. He had requested permission to interview employees and staff on duty at the time of the celebration. The purpose of the interviews was to establish whether they knew about the incident and to gather information about the incident. The scene had been, and we use his term, Your Worship, we quote him, reconstructed by Sergeant Becker to ascertain where the spent cartridge had been picked up. He had received a copy of the viral footage that depicted accused 1 firing shots with what, in his own terminology, Your Worship, appeared to be a firearm. Sixthly, a CD was made of the viral video footage and it was sealed in a forensic bag. Accused 1 and 2 had been identified as having been on the stage at the celebration. A search warrant was applied for and obtained to ascertain whether accused 2 had rifles in his possession that could fire that cartridge casing. Accused 2 cooperated fully and assisted throughout the process. Rifles were received in 3 batches and tested. He was not a ballistic expert, but could clearly see muzzle flash when accused one fired as viewed on the viral video footage. Then there's a quote, Your Worship. One can see where the shots are being fired on the side of the stage and during the reconstruction at more or less the same area where the cartridge was found, as pointed out by the witness. And finally, the recovery of the further footage was just a confirmation of the incident together with the viral footage that was circulated. Having said that, Your Worship, when he was cross-examined, he made the following concessions. First, he had not of his own accord mentioned the 5 VIP Protection Service members of the SAPS that had been on the stage at the celebration. And I pause here, Your Worship, to highlight that Your Worship even commented at that stage that Your Worship was astounded or seemed shocked at the very least to be told at that late stage that there had been 5 members of the SAPS at the celebration who had in fact deposed to statements. There was no prior mention of this, and he never mentioned of his own accord, and he referred to it as a unintentional omission, and we had many of those with respect to Your Worship. Secondly, he had seen the statements of these officers, and they had stated therein that they had not seen any shots being fired by accused one. Thirdly, had they seen a crime being committed in their presence, they were obliged to have reported this, but had not done so. Fourthly, there was no connection by means of DNA or fingerprints between accused one and the suspected firearm. Fifthly, there was no connection by means of DNA or fingerprints between accused one and the spent cartridge. Sixthly, he had not searched accused one's home or workplace for any such firearm. Seventhly, no powder residue tests were conducted on the suspected firearm. Eighthly, no eyewitnesses had complained about any conduct at the celebration. Ninthly, no eyewitness had been called to testify. Tenthly, he had not traced the photographer of the viral video footage. 11th, the chain of custody of the viral footage only began when the CD was created. He was unaware of the viral footage having been downloaded onto an external hard drive. The viral footage had never been authenticated and manipulation could not be excluded. The item that he had referred to as being what appeared to be a firearm could not be identified through enhancement and still photos. There had not been a reconstruction of the scene but merely a pointing out. So where he said earlier, Your Worship, that the scene had been reconstructed and it had been ascertained that
Whoever's phone is ringing, please leave the courtroom now. Leave the courtroom.
we were on 9.15, Your Worship. There had not been a reconstruction scene. I beg your pardon, Your Worship. I wasn't.
It's the gentleman in the red shirt there. Please leave the courtroom. Your phone was ringing, sir. Your phone. Yeah. Thank you. Apologies. We'll proceed with 9.
I apologize, Your Worship. I wasn't following.
No, you can't. I also wasn't until it started doing of the numerous requests.
Thank you, Your Worship. 9.15. There had not been a reconstruction of the scene, but merely a pointing out. So what the point that I'm making there, Your Worship, is that
the next person, and I'm going to warn you, I will clear the court or invoke provisions of Section 108 if it doesn't stop. For those who doesn't know what it means, I will proceed with contempt of court proceedings. Clear? Thank you.
we were on 9.15, Your Worship, and the distinction that I'm making there is between a reconstruction, which was explained during cross-examination, where you reconstitute the stage, the structures that were there, and you fire with a firearm to reconstruct the scene of the alleged crime. This was not the case. What he had referred to as a reconstruction was nothing other than a pointing out that in itself was inexplicable in relation to the allegations. And we say this in 9.16, he could not explain how the spent cartridge could have ended up where it was found. The cells and equipment had been thoroughly examined and no damage was found. He could not say whether a stage gun or blank gun had been used. And finally, he could not deny that a stage gun or blank gun emits muzzle flash. Then we have a summary, Your Worship. We respectfully submit that accused 1 is entitled to a discharge at the close of the state's case in that. Firstly, the state has not led any evidence to show that accused 1 possessed or shot a .223 Norinco rifle and or a firearm the make of which is unknown to the state without holding a license, permit or authorization. Secondly, the state has not led any evidence to show that accused 1 unlawfully possessed ammunition to hit a .223 Remington bullet without holding a license, permit, dealer's license, manufacturer's license, gunsmith's license, import or export or in-transit permit or authorization to do so. Thirdly, the state has not led any evidence to show that accused 1 unlawfully discharged a firearm to wit a .223 Norinco rifle and or a firearm the make of which is unknown to the state in a built-up area or any public area to wit the stadium. Fourthly, the state has not led any evidence to show that accused 1 unlawfully failed to take reasonable precautions to avoid danger to personal property and that accused 1 had control of a loaded firearm to wit a .223 Norinco rifle and or a firearm the make of which is unknown to the state in circumstances where it created a risk to the safety or property of the general public attending the celebration. And fifthly, the state has not led any evidence to show that accused 1 recklessly endangered a personal property and that accused 1 unlawfully discharged or handled a firearm to wit a .223 Norinco rifle and or a firearm the make of which is unknown to the state in a manner likely to injure and endanger the safety or property of the general public attending the celebration. Residents of Ndantani and the employees of Gear House with reckless disregard for the safety or property of the general public attending the celebration. The residents of Ndantani and Gear House employees. And we say most significantly, accused 1 is not required to give evidence to supplement the state's case. Now pause to explain here, Your Worship. What the state was required to do, Your Worship, in order to put forward a case for the accused to answer would be to reconstruct the scene, have a ballistics expert fire or anybody fire shots at that reconstructed scene to see where the spent cartridges would land, what the range would be, and what damage could potentially have been caused. We were totally unaware of that. Alternatively, and as a second option, but I believe that it should have jointly been done, Your Worship, is the state ought to have called an eyewitness who said, I was there, I saw live shots being fired, I was damn scared, I had to jump for cover, otherwise I would have been shot. The bullet missed me by 1 meter, 2 meters, whatever the situation is. There's no such live testimony or reconstructed testimony, Your Worship, to substantiate the allegations against the accused. We then turn to the relevant legal principles of Section 174 of the Criminal Procedure Act 51 of 1977 and say that this provision provides as follows. If, at the close of the case for the prosecution at any trial, the court is of the opinion that there is no evidence that the accused committed the offence referred to in the charge or any offence of which he may be convicted on the charge, it may return a verdict of not guilty. The procedure enacted in Section 174 of the Criminal Procedure Act is nothing new, and both the predecessors of the current Criminal Procedure Act contain similar provisions. It is trite law that the words no evidence do not mean no evidence at all, but rather no evidence on which a reasonable court acting carefully might convict. And that's the test, Your Worship. And that's why we submit that there ought to have been an eyewitness or reconstruction to illustrate and to substantiate the allegations against the accused. Whether or not to refuse or grant a discharge at this stage of the trial entails the exercise of a discretion by the trial court, it may grant it or it may refuse to discharge the accused, thereby placing him on his defence. The manner in which this discretion by the trial court must be exercised has always been contentious, as is evident from a number of decisions. The entire history of the jurisprudence pertaining to this section was referred to by Traversa DJP in State v. Dewani, 2015 JRL 32655, WCC, the Western Cape High Court, which summarized the advent and application of the interpretation of Section 174 in a constitutional dispensation. In the matter of State v. Shopping and others, Himstra CJ reviewed the case law history of discharge applications and formulated the test as follows. At the close of the State's case, when discharge is considered, the first question is, 1. Is there evidence on which a reasonable man might convict? If not, 2. Is there a reasonable possibility that the defense evidence might supplement the State's case? If the answer to either is yes, there should be no discharge and the accused should be placed on his defense. However, the second leg of the test did not always find favor. In the matter of State v. Puravatu and others, Dutoy AJ criticized the approach followed in State v. Shopping and stated as follows. The presumption in favor of innocence, the fact that the onus rests on the State as well as the dictates of justice in conviction other than if he enters the witness box and incriminates himself. In deciding whether an accused person is entitled to be discharged at the close of the state's case, the court may to go testify, yes, they're all in doubt, they don't know what it is, but I want to tell the court it was a real firearm. And that would be ridiculous to expect that to happen, Your Worship. That's not probable, Your Worship, it's highly improbable, and it's not the way that the presumption of innocence works. He's entitled at this stage to be presumed innocent, insofar as not one particular witness can come to court and say, that which you see there, and that which was fired on the stage was, in fact, a firearm. He's thus entitled, Your Worship, at this stage to a discharge. There's nothing that even would go further, even if one couldn't identify, let's just say the visuals were unclear, no video was taken, but if one said, and there was the following damage, there was a bullet hole through the sail of a tent, there was it lines up in the trajectory, as the court will often hear in lots of cases, of where the spent cartridge was ejected from the firearm, or there's a hole that lines up with where the bullet or projectile would have left the barrel of the firearm. One cannot then say that an actual firearm was fired. It's consistent with there being no case to answer, Worship, in relation to the onus of proof in 174. We thus ask for the discharge of the accused number 1 at this stage, Your Worship. I have no further address unless Your Worship wishes to hear on any particular point. Thank you, sir.
Thank you, Your Worship. Your Worship, if I may hand up our original heads of argument, signed by myself as well as my attorney. Thank you, ma'am. In somewhat of a different approach to the heads of argument, the first 7 paragraphs deal with the aspects, the legal aspects of a Section 174 application. I'm not going to repeat it because Mr. Hodes SC has eloquently placed the correct legal situation before the court. I ever do wish to emphasize the decision of State versus Nkosi and another 2011 volume 2, the South African Criminal Law Reports, at page 482, a decision of the Supreme Court of Appeal. In this particular judgment, handed down by Madam Justice Meyer, Judge of Appeal at that time, it deals with the aspect of there being more than one accused in the witness or having been charged. I say this because even in the decision of Lebaxa, there is an indication that the state is entitled to rely on the evidence of a co-accused to implicate another. In the decision of Nkosi, Madam Justice Meyer sets out that the failure to discharge a co-accused because he might be implicated by his co-accused, and there is absolutely no evidence during the trial, whether being in the cross-examination or whether being what has been stated, in itself is undoubtedly denying an accused a fair trial. That decision speaks for itself. Your Worship, I'm sure if you read it, there is no need for me to emphasize the aspects of that. Your Worship, from paragraph 7, we have dealt with the 2 counts which are applicable to accused number 2. It is important to note that the cases of accused number 1 and 2 are completely different in a sense that the counts applicable to accused number 2 relate in essence to the handing over of a firearm to accused number 1 under circumstances where accused number 1 has no authority to possess it. Following from that, for some reason, it is argued by the state that accused number 2 then also places all the occupants of the stadium and the surrounding area in danger. Paragraph 8 of our heads of argument deal with the questions asked of the state in further particulars and the reply given by the state. What I've done, Your Worship, you will see, is that I've set out the questions and I've set out the replies given by the state to both count 4 and to count 6. Now, all that I wish to emphasize from these particular counts is that the state has conceded in the further particulars, as is also evident from the evidence which has been led before the court, that there's no statement by a member of the general public to the effect that they were frightened, and secondly, that there is no statement from any person. You can testify that accused number 2, in fact, handed over a firearm to accused number 1. Now, this whole case as regards accused number 2 centers around this particular issue. We are not involved or don't want to get involved in credibility of any witnesses. I say so because there are no witnesses whose credibility I can attack, because there are no witnesses who have testified that accused number 2 handed a firearm to accused number 1. I deal in paragraph 10, Your Worship, with the accused plea at the beginning of the trial. He stated, "We place all the elements of the offence in dispute and specifically deny handing a firearm or ammunition to Mr. Malema at any stage." In paragraph 11, I deal with the effect of a plea in terms of section 150, because it's quite obvious that this aspect seems to get lost in the criminal trial. In this matter, Madam Justice Steyn, in the Duma case I've quoted, set out the judgment in Motlapeng by the judge present at the time, Van Rijn, and it sets out the consequences of a plea in terms of section 115. It says, firstly, what is stated in the explanation is not evident. It is a disclosure of the accused's defense. Secondly, the accused exercises an election to make one and should not be coerced into making one. Thirdly, if the accused tenders a plea explanation, then it forms part of the evidential material, and the accused may be cross-examined on the contents of the explanation. D, the plea explanation cannot be used as evidential material in favour of the accused without him testifying under oath. But the next important aspect, throughout the trial, the explanation would operate in favour of the accused in that the state, and it's underlined, is obliged to disprove the defence raised in it. And Madam Justice Steyn indicates that this is a translation of the court's words at 761 to 762E. The original text of Van Rijn JP was in Afrikaans. The importance of this, Your Worship, is that from the outset of this particular case, accused number 2 has placed in dispute the fact that he ever handed a firearm or any other object, for that matter, to accused number 1. The duty was on the state, and they was obliged to disprove that defense. Now, paragraph 12 and 13, 14 deals with certain aspects where indeed I deal with the aspect that there is no evidence that has been led that accused number 2 ever handed a firearm to Mr. Malema at any stage during that evening. The closest we've got in this case is Mrs. Govender who made an assumption that because accused number 2 was on the stage, close to the vicinity of Mr. Malema after the shooting, she assumed that Mr. Malema had handed the firearm back to accused number 2. But just for the moment, presume we can assume that. That is not the offence. That is not the offence the accused is charged with. The offence is the accused too is charged with handing a firearm to Mr. Malema under circumstances where Mr. Malema was not legally entitled to possess that firearm. While I'm busy with that, what evidence is there before this court that he wasn't in fact legally entitled to possess it? Absolutely nothing. Now, you will see in the further particulars, and I realize Mr. Caesar only came into this case at a later stage. He seemed quite surprised about the cross-examination of the person by the name of Larry Mavundla. But if one looks at the further particulars, then the state was making the allegation from the outset that the firearm in question had been booked out to Mr. Larry Mavundla, that he was at that stadium on the night in question and was in fact in East London for some time prior to that, because they had traced his cell phone. The state alleges he was on the stage. Now, no statement has been obtained from Mr. Mavundla as to what happened. Did he have his firearm on the night in question? And who did he hand it to, or who did he give it to? We have the evidence of Colonel Janssen, who met Mr. Mavundla in Durban. Mr. Mavundla said, yes, the firearm you're looking for, because I'm told we need to hand over our firearms. And Colonel Janssen at that stage testified that Mr. Mavundla said to him, but this firearm was not in East London on the evening in question. So this is not something that has been sucked out of somebody's thumb from the very outset of this particular case. Mavundla told Colonel Janssen, but my firearm wasn't in East London on the night in question. Whether or not it was, of course, it's got nothing to do with us. Because even if it was here, the state has not produced any evidence to show that we handed it to Mr. Malema. The further particulars allege the following. Accused number 2 is seen at the back of the stage carrying a rifle. Now, I want your worship just to search your memory, and I know it is very good. And the notes your worship has taken in this case are very accurate. But accused number 2 is seen at the back of the stage carrying a rifle. Secondly, it's alleged Mr. Snyman is the only white male on the stage before and after the shooting. Again, we search our mind, there is no such evidence. Mr. Snyman handed a rifle that belonged to tactical security to Mr. Malema. Now, where in heaven's name did the state in its further particulars get that information from? Unless there's a witness they have that they decided not to call, who can come and tell us, I was there, I saw Mr. Snyman hand the rifle to Mr. Malema. Because with the greatest of respect, we have heard absolutely no evidence to this effect. Then the state alleged in the further particulars, Snyman was present when the shots were fired. There's no evidence that he was present when any shots were fired. Your Worship, why I say we don't even have to deal with aspects of credibility is because there's nothing to compare. There's no witness who can say whether it's credible or not. Because there is simply nobody who has come before this court who can substantiate the claim that Snyman handed the firearm to Mr. Malema, if indeed it is a firearm. Now, His Lordship Mr. Justice Nugent in the Lebaxa case made the following remark. He said there should be reasonable and probable cause to believe that the accused is guilty of an offence before a prosecution is initiated. You cannot make assumptions and prosecute a man in the hope that something might come out during the trial which is going to implicate him. Prior to you prosecuting him, you must have prima facie evidence that he has committed the offence in question before you charge anybody. And I submit with the greatest of respect, and we will see if the state can stand up here today and honestly tell you that it has produced any witness that Snyman handed a firearm to Mr. Malema. I did glance through Mr. Caesar's heads of argument, and I see he has quoted the old classicus of State versus Blom, dealing with the inferences one may draw from certain. Blom starts off with a very important proviso, and that is the word proven facts. If one wants to draw an inference, it can only be drawn from proven facts. It has a second leg. Those proven facts must also be the only reasonable inference that can be drawn. But at the start off is that there must be proven facts. There's no proven fact yet. As I've stated, Your Worship, there is one concern I have, is that we have two accused persons before court. This is a highly political case. But under the circumstances, it is quite obvious and clear that neither Mr. Snyman is implicating Mr. Malema or Mr. Malema is implicating Mr. Snyman. And under those circumstances, as indicated by Madam Justice Maya, Judge of Appeal as she then was, it would be a complete, as she stated, if I may just get her wording, I don't want to misquote her. It would undoubtedly deny him a fair trial if he was not granted a discharge at that stage. Thank you, ma'am.
I have provided my learned colleagues with copies of the head.
So you're saying you're ready to proceed?
That's correct, Your Worship. I have drafted the heads in anticipation for what might be argued today, so I'm ready to proceed.
Thank you. You may proceed.
Thank you, Your Worship. The state is indeed opposing the discharge of the accused and submit that the evidence presented by the state during the trial is overwhelming against the accused. Bishop state led the oral evidence of several witnesses, and such evidence was corroborated and substantiated with real evidence in the form of the video audio clippings depicting accused number 1 firing several shots in the air. A spent cartridge that was found at the scene, which later linked the firearm owned by the company of accused number 2 to that cartridge case in question. Accused 2 is also visible in the video footage where he is seen approaching accused number 1 after the shots were fired. This happened in a matter of split seconds. Accused 1 and accused 2 are seen walking towards each other, and thereafter accused number 2 moves away from accused number 1. Subsequently thereafter, accused number 1 is no longer in possession of the said firearm. A more detailed discussion will then follow below. Bishop, the section 174 in the context of this trial have already been argued by both counsel for accused number 1 and accused number 2. I do not wish to repeat. The principles are the same relating to what has been said in terms of section 174, discharge. In respect of this particular section, the sole discretion whether to discharge an accused is upon your worship. Where more than one accused is charged with the same offense, the court may refuse a discharge or to discharge one of them if it is in the interest of justice to do so. It is our submission that it is indeed in the interest of justice, more specifically relating to accused number 2, the discharge that have been requested and the facts that have been laid before your worship, and I will substantiate my argument to your worship. On page 3, at paragraph 10 of my heads, I want to refer the court to State versus Gozo and another, in brackets 2194, in brackets 1 BCLR 10 Sky, in brackets the question of fundamental rights in section 174 was considered in respect of the Bill of Rights of the erstwhile Republic of Siskai, where Heath J. said the following would probably give effect to the wishes of society and the purpose of the Constitution. 1. An innocent person, as far as possible, must never be convicted of a crime. I am in full agreement with that. The conviction of a guilty person must be obtained with the best possible endeavors. The right to remain silent and the satisfaction of the onus which is on the state must be satisfied as far as possible. For the rights of an accused is very important, but the rights of the community to see that justice is done is equally as important. To achieve this goal to everybody. These 6 principles are indeed very important if you look at the issues that has been raised in this particular matter. This is why I will submit that very few courts are placed in the position that your worship, this court, have been placed with real evidence, a real video footages from different places, gear house, as well as a viral footage. a real firearm that was brought to this court belonging to the company of accused number 2. A real spent cartridge was brought for the court to examine, to look at it, look at the firearm, look at the footage. I'm of the view, and it's my submission, that the court was placed in the best position to assess the evidence, to look at it, and make its findings in this regard. Bishop, I've summarized the evidence of all the witnesses. Mr. Otis already went through it. What is of importance from this particular summary that is the 15.2, Colonel Ngamlana Nkwali, the one that opened the criminal case, that was present on the evening in question. He testified that he didn't see anything what transpired, but he was later sent this particular viral footage, of which he was of the view that in investigation a docket must be opened and an investigation must commence. What's also of importance of his evidence is that he said there were no prior agreements between him or any member of the party or any of the accused that assimilation of a firearm would be firing shots was discussed, and he would have to give permission in order for that to happen. I want to also refer the court to the evidence of Ms. Ntombe Fikile Mankomo. She's the one that found the specific spent cartridge. That was the cleaner that was there 2 days after the incident on the 30th of July. What's important of her evidence, usually this is just a normal, ordinary person that was performing her duties on the day in question. She's got no interest in this particular matter. She didn't even know what was that spent cartridge that she picked up. As a result, she asked Mr. Kumalo, who was working for BCM, what this was. He took a photo of the spent cartridge and then informed her that she must hand it over to her supervisor, which she did. This witness, as unsophisticated as she was extremely honest to such an extent that the evidence remained intact. What is also of importance from her evidence is the issue that was raised as to where exactly this firearm and the possibilities and impossible probabilities. Usually, even if she found that spent cartridge in the air, the fact of the matter is that it was found in the area or in the stadium where these shots were fired. Where she found it, in my submission, is irrelevant. What is of importance is that coincidentally it was found on the side which one can see, or in the direction where these shots were fired into. What is also of importance that the incident occurred on the 28th of July. That was in the evening. The 29th, that stadium was still, or the stage, that is the word I'm looking for, was still there on the 29th. It wasn't dismantled. They just started to dismantle it. On the 29th, and on the 30th. Usually my submission is really irrelevant as to where this spent cartridge was found. The fact of the matter is it was found, whether it was in the air or on the other side of the stadium, on the left or the right side, it was found on the stadium. I want to take the court then secondly to page 6 on paragraph 15.7, the evidence of Colonel Jansen that was also mentioned by counsel for accused number 2. What is of importance that when he arrived there, visiting the premises of accused number 2's business, instead of all the many firearms that were there, he was given, or 2 firearms were produced, the one that was linked to this particular incident, and then a 9mm Glock. If one look at the footages, a handgun was also, shots were also fired from a handgun, despite the fact that the accused were not charged for that offense. It cannot be coincidence that accused number 2 knew at that stage that these were the firearms. He had many firearms on that premises that the police came there to look for. And the reason this was done, it's my submission, that accused 2 did not want to disrupt his business because he suspected that all the firearms will be taken by the police for ballistic test. As a result, that's why his attorney had to intervene so that batches could be taken, because it would have been disrupted. His business would have been disrupted if all the firearms were taken for ballistic testing. The question then arises, how did he know that these were the 2 specific firearms that were the police were searching for? And coincidentally, one of that firearms tested positive to that particular scene here in Mdansane at the Sisha Dukasha Stadium. To me, it's very important. Accused number 2 knew because he was there and he participated in what transpired on that evening in question. He knew that was the first firearms that were used by Mr. Malema, both the 9mm Glock and the 2.223 firearm that was brought to this court, where Mr. Gadleka linked that firearm to that spent cartridge. We have now the firearm that was used. We've got the spent cartridge. I'm going to the video footage relating to this. What is also of importance is the evidence of Colonel Gadleka, that he was very objective in his evidence. He's an experienced colonel that testified how he managed to link, despite the fact that the breech block of this firearm and the firing pin of this firearm was removed. In order to affect the results, he was still able to find 3 points and match that spent cartridge to the firearm that belongs to accused number 2. I've heard the cross-examination of counsel for the accused relating to the breech block and the firing pin, and why the accused was not charged for defeating that thought did cross my mind. If I had more time to peruse everything, I would have charged him for that. It's clear this was done for the sole purpose to defeat the ends of justice. Then we look at the evidence of Ashley Singh. I'm not going to go through it. Samuel Kwata and Sibusisi Ngobo relating to the Gear House footage. What is important from this specific footage of the Gear House, it confirms the incident did transpire as per the viral footage. The viral footage was just taken from a different angle. From what I could view, it was taken from that particular stage where the incident occurred. But if you look at both footages, even the singing, the song that was sang at that particular time, the court can safely exclude that there was any tampering or that there was any amendments or alterations to the viral footage as counsel want to allude to. To do that would just amount to sheer speculation, whereas the Gear House footage have already been authenticated. We have argued this issue relating to admissibility thoroughly on the previous occasion. That horse has bolted already. The only issue that the court must decide on is the relevance of those particular videos, not their authenticity. It has been stated in many case laws, which I've mentioned before. It has been confirmed by the Supreme Court of Appeal. Your Worship, I only want to deal with the evidence now of Colonel Rodney Stephen Swartboy, who's the investigating officer, and how he explained what unfolded during his investigation. The only issue that is really of importance from his evidence is the chain relating to the firearm that was linked, how he found the firearm at Brighton Beach from Captain Creer and brought it to the ballistic section here in Kabeja for ballistic tests to be conducted. Much has been made of the fact that he didn't disclose that the close protectors were on the scene, and Your Worship, it's not our job. Our job is to prove our case. The information was disclosed to the defense. They must do their work. It wasn't hidden from them. Everything that was put to Colonel in this regard, Colonel Swartboy, it's not our work to do that. Our work is to disclose all the informations, those that benefit the accused and those that are against them. Your Worship, insofar as his evidence is concerned, it was also said as to the close protectors that didn't see, they were on the stage and so on. It is clear from this, Your Worship, if one take into consideration accused number one's own version that he fired shots on the night in question during that incident, it's clear somebody's lying here as to whether either the close protectors were there and they didn't see or they were not there, because in his own version contradicts exactly that point that this incident happened as described in the video footage. They were either not present, or they didn't observe anything, or they were deliberately untruthful. It leads to the inescapable conclusion that they were untruthful as to what transpired on the night if they were on that stage. Because accused number 1 confirms this incident. It did happen. He just says it's a toy firearm. We're saying it's a real firearm. It also begs the question, Your Worship, that it was raised that we didn't have any eyewitnesses and so forth. If the members of the South African Police Service that were close protectors on that evening did not want to or were not prepared to come and testify, how can we expect an ordinary member of the public that were there to come here and say that is exactly what we have seen? And also take into consideration most of the people that were there were EFF supporters. So it's not strange that no witness came forward to come and testify, as been put like by my counsel for accused number 2, that this case is highly political. What is important about this, it is evident from the evidence from Colonel Nkwali, from Warrant Officer Becker, Colonel Godleka, Colonel Mzuku, Warrant Officer Steenkamp, Captain Botha, Captain Governor, and Colonel Swartboy, all of them being experienced members of the South African Police Services that uses and utilize firearms, a tool of their trade, are talking about this muzzle flash they observed on the video footage. They were not prepared to commit that this was indeed a real firearm, but this was an issue that kept on being raised about the muzzle flash, which they observed during. The only reason why they couldn't commit to that because none of them are ballistic experts, but Mr. Godleka already confirmed that this firearm was indeed there and that firearm was used during this incident. It's linked to that cartridge. The submissions made by accused number 1 and 2 during the cross-examination of Mr. Singh, Mr. Kwata, relating to the issues of the footages, like I've said, Your Worship can safely accept that footage is authentic. There wasn't any tampering. To do anything else would be a speculation of Bishop, insofar as the witness is concerned, that we don't have any witness, I think we brought to Your Worship the best witness ever. It's a silent witness in the form of those video footages. It's better than an actual eyewitness's evidence, which enable the court to see what exactly transpired during the incident, as the contents thereof is unbiased, it's unemotional, it does not exaggerate, nor does it take any sides, and it doesn't have the preconceived perceptions, does not have any of the fallible qualities that one can attribute to human beings. It doesn't fabricate a version. It just shows what it has recorded during the incident on the press of a button. What better witness would Your Worship would want in a form than that witness? It was said that the state didn't even prove its case because there was no witness, there was no this and that. Beyond reasonable doubt was described by Denning J. in a matter of Miller versus Minister of Pensions 1942, all ER at page 372 as follows: the degree is well settled. It need not reach certainty, but it must carry a high degree of probability. Proof beyond reasonable doubt does not mean beyond reasonable doubt or beyond the shadow of a doubt. The law would fail to protect the community if it admitted fanciful possibilities to deflect justice. If the evidence is so strong against a man as to leave only a remote possibility in his favor, in which can be dismissed with a sentence, of course, it is possible, but not probable. The case is proved beyond reasonable doubt, but nothing short of that will surface. 1 + 1 = 2, plus another 1 = 3. Your worship's got the video footage, your worship's got the spent cartridge, your worship's got the actual firearm. You've observed it. It's my submission that that is proof beyond reasonable doubt. Bishop, I submit the dictum that I've just stated is applicable and relevant to this case. It's highly improbable that the accused, one, fired several shots with a toy firearm or a movie gun. If the court considers that no prior discussions took place with this Colonel Mkwali. If one look at the footage, you don't need to have been an expert to see it looks similar to the actual firearm that was produced here in court. If you look at length and size, it was already confirmed by Mr. Guadaleka that indeed a real firearm fired that spent cartridge on the night in question. Also of importance is if one look at the actions on the video of accused number 1, he doesn't with this toy firearm fire into the crowd or fire to his gentleman that was on the stage with him. No, he takes a secluded place, moves to the right side of the stage, the far right, and he fires the shots there. Where there were either no supporters or very minimal supporters. If this was a toy firearm, you could have just moved it around, fired to everybody else because he was showing it off. Why didn't he do that? That's an issue the court must also consider if one look at the actions of accused number 1 on the night in question, or it was clear that that was a firearm if one look at his actions. This is why I have stated, and it's already been stated by counsel that he spoke about R versus Blom. The only reasonable inference the court can draw is that indeed that it was a real firearm, because this is the issue. Insofar as accused number 2 is concerned, one can clearly see from the video footage there's a discussion between him and accused number 1. Accused number 1 moves towards him, smiling, both of them. Moves towards him, give what looks to appear that he hand over the firearm. The court can draw an inference. After that, accused number 2 is seen moved away. Accused number 1 is no longer in possession of the firearm. What other reasonable inference can be drawn from that? If accused number 2 was not the bodyguard of accused number 1 on that evening in question, what other purpose would he have been here in East London with accused number 1? The court is not obliged to indulge in a conjecture and to find the answer for every possible inference if one look at this incident. You're not required to seek speculative explanation for conduct which on itself, on the face of it, is incriminating. It's submitted, Your Worship, that the evidence that was presented before court is strong, and that the application for a discharge 17 can safely be dismissed in respect of both accused. That's all sufficient.
Yes, yes.
The light is blinding me, so it's impossible to look up or see anyone or even the time. Thank you. I couldn't- Yes, thank you. At least I couldn't look up at it. So, you want to apply now or after the tea adjournment? Put it to 11, then we'll take tea 10:30 to 10:45, or we can continue to 10:45 and then take it from there.
I'm in your worship sense. I could reply, but if there's a need for a tea break, your worship, then perhaps it is an opportune time to take the tea adjournment, and I can reply after the tea adjournment.
And there's one other court official that we could see here.
Yes, Your Worship, I think probably more instructions might also come from the accused towards the, it's a proper time. Thank you.
The court is in agreement with the sentence.
I'm in agreement here.
man was there, he saw everything, but he never saw a shooting. Then we moved on to Mankoma, who pointed out the location where the cartridge was retrieved. On his own version, as I illustrated to us, photos were taken over pointing to the location by Sergeant Tuzi. The photo album was handed me in the exhibit. We agree with that, Your Worship. We move forward, Your Worship, to Jothan Kumala, who says he heard, and this is in 15.5, he testified that he heard a series of cracking sounds just before the EFF's event came to an end. He was unable to say whether it was gunshots or the fireworks that were displayed at the end of the event. So now we have a number of factors to take into account, and we move forward on his own summary, Your Worship, to 15.9, Warrant Officer Philip Becker, who in line 4 of 15.9 says he took it to the laboratory and swabbed it for touch DNA as well as fingerprints. He found fingerprints on the spent cartridge, but the accused were excluded. We then move across to Colonel Mandisi Magwadleka, who found 3 identifiable marks and tries to infer that that in itself should be sufficient, whereas Your Worship is well away from the cross-examination that there's no set amount of identificatory marks and no standard test that's applied. We then, Your Worship, move in his heads of argument in 1511 to Ashley Singh from Gearhouse, who he says saw for the first time in the footage that accused one fired several shots from a rifle during celebrations. There was muzzle flash, but he conceded, and this is at the foot of page 7 at the end of 1511, the witness conceded that he's unable to dispute that it was a real firearm. I think he's saying that he was unable to dispute that it may not have been a real firearm, but that's what he says. Then you have Quata, who during the event did not see accused one firing shots from Gearhouse. Similarly, Sibusiso Kobo, during the event did not see accused one firing shots. Then we move across, Your Worship, to Yvonne Steenkamp, the warrant officer, was unable in 15.15 to confirm that she was unable to confirm whether the firearm was a real firearm or not. We then have a first reference, Your Worship, in 15.16 to a second copy of the footage, which was the testimony of Sergeant Dwayne Francis. But then we move across to Captain Rian Botha, who also was unable to confirm whether the firearm was a real firearm or not. This is in his heads of argument, Your Worship. Then we have Colonel Rodney Swartboy, who he says is a repetition, and that he says the defense made much of the fact that Swartboy did not testify regarding the fact that the members of the SABC, that was the close protectors of accused one, stated they did not see accused one firing shots on the date of the incident. So you have all the eyewitnesses not seeing any shots. Then he says in 16, it's not that, and this is what I find astounding, Your Worship, where he has regard to what the role of the state is, the prosecution. He says it's not the role of the state or the state's duty to prove the case for the defense. The information has been disclosed to the accused. It is further submitted that the close protectors did not see the accused firing shots in the air during the incident. Then he comes at the end of that paragraph to the following. The inescapable conclusion should be reached that the close protectors were either not present or observed during the incident or was deliberately untruthful in this regard. So a state who's meant, in my respect for submission, to see that justice is done and put all the evidence before Your Worship, see anything that's exculpatory as putting forward the case for the defense, and that they then explains away the deficiency by saying either they weren't present or they were deliberately untruthful. But I don't know which inference you draw with any certainty from the conduct of the state in that regard with respect, Your Worship. Then, when it comes to corroboration and supporting evidence, is at page 11, paragraph 17, which is the most telling, Your Worship. I'm going to quote from my learned friend's heads of argument to Your Worship. It says, it is evident from the evidence of Colonel Nkwali, Warrant Officer Becker, Colonel Magwadleka, Colonel Mzuku, Warrant Officer Steenkamp, Captain Botha, Captain Governor, and Colonel Swartboy, all of them being experienced members of the SAPS that use firearms as a tool of their trade, testified about the muzzle flash they observed on the video footage, albeit the fact that they did not commit to state that it was indeed a firearm that was used by the accused. Bishop, that's the state's version. They ask you, and I'm going to deal with this later, that's why I say it's peppered with contradictions and unanswered questions, Bishop, because we say you cannot disprove that it was a stage or blank firearm, and he concedes it here in paragraph 17 on his own version, Bishop. And what we say, Your Worship, is that not one of them could say that blank or staged firearms did not emit muzzle flash. They used this muzzle flash as the test, but all of them said they can't say whether a stage or blank firearm does in fact emit muzzle flash. So then, from having said that, Your Worship, he submits in the next paragraph the probabilities are high that it was a real firearm. Bishop, that's mutually destructive of one another with respect. The expert policemen who use firearms as the tools of their trade on his own version were unable to say, but you, Your Worship, must look at the video and draw the inference that they couldn't. That's the argument that he puts forward. Your Worship, in 21, I'm going to deal with this in greater detail later on because of his oral submissions. He says, Larry Mavunda was on the stage when the incident occurred and was the person who accused one handed the firearm to. I just need to repeat that, Your Worship, because it goes against everything that he argued on his feet. He says, Larry Mavunda was on the stage when the incident occurred and was the person who accused one handed the firearm to. It is submitted that this is still quoting, Your Worship. It says, it cannot be true that the firearm in question was in Johannesburg during the incident, as it would not have been possible to link it to a fired cartridge case that was discovered at the stadium 2 days after the event. This would mean that Larry Mavunda must have fired shots with a firearm that is alleged to have been in Johannesburg at the time. Worship, that's something that fits in with my final and my opening statement. It's a case we've never heard with respect to Worship. I don't know how one draws the inference that Larry Mavunda must have fired shots with a firearm that is alleged to have been in Johannesburg at the time, from the facts that he uses to come to that conclusion. Because it's a conclusion, he says this would mean that Larry Mavunda must have fired shots with a firearm that's alleged to have been in Johannesburg at the time, and it must be coupled, Your Worship, with what I'm going to argue later on, that he said that Larry Mavunda ought to have been charged. Larry Mavunda isn't charged. I don't know if he expects Your Worship to find him guilty without being charged. Worship, in 25, he says, it's admitted that the video evidence is better than that of an eyewitness to determine what transpired during the incident, as the content thereof is unbiased, unemotional, and does not exaggerate, nor does it take sides or possess preconceived perceptions. It does not have any fallible qualities that are attributed to human beings being eyewitnesses. Saying to you, we've done better than providing you eyewitnesses, Your Worship. We're giving you footage. But then, Your Worship, you're going to see, he argues later on, you must draw inferences from the footage. You mustn't just look at it. Because the footage doesn't depict what he set out to prove. In 27, Your Worship, at the foot of 27, he says, lastly, if the firearm was indeed a toy or movie gun as alleged, it raises the question why accused one did not aim the firearm towards the supporters or the persons present on the stage, but elected to move towards the end of the stage and fired in a direction where there were minimal supporters, if any. And he argued this as well orally, Your Worship. Now, we have a charge of endangerment of people. Now you're saying that the person acted in such a way to ensure that nobody was endangered. They are self-defeating with respect to Your Worship and mutually destructive of one another. Now, Your Worship, I've just read to you what he said about Larry Mavunda, and he refers to Larry Mavunda again in paragraph 29. And he says, in addition, accused two's version that Lady Mavunda was put only at a late stage when Colonel Swartbo was testifying. This version was not put to Colonel Mzuku or Captain Government during the evidence, whereby they implicated accused two as the person to whom the firearm was handed to. Now, it was never put to them, and it was never conceded with respect to them. Don't act for accused two, Your Worship, that he was the person to whom the firearm was handed. In fact, the video was played and we saw the opposite. So I don't know what we infer or see or don't see and must infer but not see in the video. But it goes back to the reference in paragraph 28 of Rex versus Blom. Worship, and if one looks at Hoffman and Zephyr, they say one cannot, with respect, and I'm actually assisting my learned friend by making two submissions. At this stage, the onus isn't proved beyond reasonable doubt. At the end of the case, it will be. It's evidence upon which a court acting reasonably could convict, so one can infer into it reasonable doubt. But in Hoffman and Zephyr, they say one cannot, at this stage, rely on Rex versus Blom. I found an authority that ought to assist Your Worship, and it's an Imperial Marine Company versus MV Pascal, spelled P-A-S-Q-U-L-E, Delegata, 2012, volume 1 of the All South African Law Reports, page 491, decision of the Supreme Court of Appeal, with Honourable Mr. Justice Wallace is quoted as saying, and it's quite an extensive quote, Your Worship, it's 3 paragraphs, but I think it sets out the case there very clearly. He says, whether there is a prima facie case may depend upon issues of both fact and law, as with Imperial Marine's claim for damage to the vessel allegedly suffered at Richards Bay and the claim arising from alleged SRB-induced corrosion. The starting point is the facts upon which any legal contentions are based. That's at page 500 C to D. It says, the Constitutional Court has recently pointed out deciding matters on the basis of concessions by counsel is not always satisfactory. For that latter reason, I indicate briefly why there is much to be said in deciding whether the applicant has established a prima facie case. For taking into account the facts in the opposing affidavits that an applicant does not contradict, at least where there is no reason to believe that in future proceedings, the advantages of discovery, those facts are capable of being challenged. And the primary reason is that in principle, to do otherwise is to shut one's eyes to relevant factual material that may fatally undermine the arresting party's claim, and courts do not ordinarily disregard relevant and admissible evidence when reaching their decisions. That's at 501G to 502A. Then finally, Your Worship, further on 502 at E to 503A, Justice Wallace says, leaving that aside, 2 other points fall to be made about the approach to proof of a prima facie case. They are first, that where the applicant asks the court to draw factual inferences from the evidence, there must be inferences that can reasonably be drawn from it, even if they need not be the only possible inferences from the evidence. If they are tenuous or far-fetched, the onus is not discharged. Second, the drawing of inferences from the facts must be based on proven facts and not matters of speculation. Now that goes against the argument with respect. And he says, in his heads of argument, Your Worship, over and above the direct evidence implicating the accused as the perpetrators of the offences, the cumulative effect of a number of probabilities pointing in the same general direction may be such as to establish the guilt of an accused beyond reasonable doubt, State versus Morgan, and then he refers to reasonable inferences, State versus Parlour, in paragraphs 31 and 32. No inference can be drawn, Your Worship, by ignoring the place where the spent cartridge was found in relation to where the stage was at the time. It would not be a reasonable inference to ignore those facts, and that's why I referred to that case. It's the evidence of the state witnesses, Your Worship, that placed the cartridge there. My learned friend argues that one mustn't have regard to it, it doesn't make any sense. But in this very same oral argument, he says to Your Worship, 1 + 1 is 2, + 1 = 3, it's logical. therefore there's proof beyond reasonable doubt. But you can't, Your Worship, ignore the improbabilities of where the cartridge was found in relation to where the accused, number one, is alleged to have shot. He further, Your Worship, asks Your Worship, having made these submissions quoting his own witnesses, he says to Your Worship, it's highly improbable that accused one shot shots with a toy or movie gun. That's something, Your Worship, that's already been said by his own witnesses that they can't disprove it. And then he goes, as I said, Your Worship, he wants to make out that he's proven what he sought to prove when he says, Colonel Ngwadleka says, a real firearm fired that spent cartridge that night. That was never the evidence with respect to Your Worship. He was incapable of saying that. That's what he may have wanted him to say, but he couldn't say it. And he asks Your Worship to then, in his oral address, draw inferences from the conduct of accused 2. Your Worship, if we've got a video where he says, I'm relying on an unbiased, perfect video, there's no need with respect to draw inferences, particularly, Your Worship, when he says that Larry Mavunda is the person in the video. So I don't know how you draw an inference from watching a video that changes Larry Mavunda to accused number 2, because that's beyond the realm of reality with respect. And then he asks Your Worship to even infer accused 2's only purpose on stage was because he's the personal bodyguard of accused 1. Why does that make him guilty of any offense with respect to Your Worship? So Your Worship, when I say that his argument is self-defeating, I want to highlight with respect to Your Worship 2 paragraphs of his heads of argument, as I alluded to earlier, that make this as clear as daylight with respect. The one paragraph, Your Worship, is paragraph 21 concerning Larry Mavunda that I've quoted to Your Worship. And what did he say to Your Worship when he was on his feet? He said, had I known then what I know now, but only came into the case later, I would have charged Larry Mavunda. That's what he told Your Worship. Well, how do you charge Larry Mavunda when you're arguing to the court that you've proven a case against accused number 2 for that which you attribute to Larry Mavunda because you saw it on a video? It's self-defeating with respect to Worship. The clearer example of all of this, Your Worship, is in paragraph 27. He's asking you, as I've told you, Your Worship, to find accused number 1 guilty of firing a firearm in a built-up area, being in possession of the firearm, the ammunition, and all the statutory offences, and endangering the people that were there, the public, the people who live in Danzani, and everybody else. But he says, but he took special aim, because he knew it was a firearm, Your Worship, to move it away from the supporters. It says, it raises the question why accused 1 did not aim the firearm towards the supporters or the persons present on the stage, but elected to move towards the end of the stage and fire in a direction where there were minimal supporters, if any. There was the objective fact that my learned friend fails to recognize in all of this, is that the bullet has to, if there was a real firearm that was fired, that bullet has to land somewhere. So you've got 3 objective facts on his version. You've got a firearm, you've got a spent cartridge. That spent cartridge had to have ejected a bullet to make it a real firearm. Then pray, I'll ask Your Worship and my learned friend, because he hasn't answered our heads of argument, where's the damage? If one expects that there was a real firearm firing a real bullet, there's a spent cartridge to substantiate all of that. What happened? Because he says, I'm charging you with having endangered these people, but you took special aim to avoid all these people because you knew it was a firearm. That in itself is the clearest indication of a self-defeating argument. And I therefore say, with respect, Your Worship, that particularly in light of the submissions made by my learned friend and the duplicitous attitude, because on the one hand he says one thing, on the other hand he says something else. The witnesses did not say that which he attributes to them. I say that on the basis of that, it is clear, Your Worship, that there is no case for the accused to have to come and answer, because it's clear on the quotes from my learned friend's own heads of argument that the witnesses conceded that they cannot dispute that this was a blank or staged firearm. Thank you, Yusuf. Yusuf, now approach the accused. I apologize. So my instruction is to add, if I may, that by now attempting to discredit the previously unheard of 5 South African Police Service specially trained VIP Protection Services members, he's actually giving evidence to try to establish why he didn't call them when in fact he had the onus to call them and he ought to have. And he has no basis to discredit them and put in his heads of argument with respect that either they're lying or they weren't there. Because they've given a statement, he has the docket, he knows what the statement say. It was put to the investigating officer, Colonel Swartboy, what appears, and he agreed with that which was put to him, that they hadn't seen, they were there and hadn't seen any shooting. And furthermore, had they seen shooting, they would have been obliged to have reported the matter. As is in the heads of argument and as pointed out by my client and in my heads, it remains unanswered with respect to Worship. Thank you.
Thank you, Your Worship. I have no doubt Your Worship has correctly recorded what Lieutenant Colonel Janssen said in front of court. So I need to correct, unfortunately, my learned colleague. Lieutenant Colonel Janssen's evidence was that Clement Mdluli and Mr. Boertes were the responsible persons for all of the firearms belonging to tactical security, not accused number 2. We've heard no evidence that accused number 2 is the owner of Tactical Security, which is a company. I need to correct that. Then, as regards his statement about the handing over of the firearm and a 9mm at the time when Janssens was there, and trying to draw the inference that accused number 2 must have known that those 2 guns were the ones that fired on the night in question, nothing could be further from the truth. Lieutenant Colonel Janssens testified that as he was leaving Tactical Security, Larry Mavundla arrived, and he who was Colonel Janssen spoke to Larry Mavundla, who said to him that I believe you are looking for all the firearms belonging to Tactical Security, and I have brought my firearm. In the further particulars which the state answered, it said the following. On the 6th of August 2018, firearm with serial number SPA 249 was presented to Colonel Janssen by Larry Mavundla. Accused number 2 had absolutely nothing to do with the handing over of that firearm. It was obvious from Colonel Janssen's evidence that he had met up with Larry Mavundla. What of course my learned friend is forgetting is that the police by that stage had already requested that Tactical Security hand over the firearms they had in their possession, which were of more or less the same caliber. By that stage, there was already an agreement that tactical security would hand over the firearm in batches to the police force. In order to do this, it only makes common sense that tactical security would be calling in all these firearms from every single corner of the Republic, because they are not a company that supplies security only in the Durban area, but throughout the country. These firearms had to be called in, and that was the evidence of Colonel Janssen, that the firearms were being brought in from all corners of South Africa to be presented to the police and to be given to them. Colonel Janssen didn't take Larry's firearm, nor did he take a 9mm from Larry on the day in question. It was handed into the company and handed over to the police, as we have heard the evidence of the investigating officer. Janssen was there in his capacity as the DFO of the province, so that he could look through all the registers to ensure that the company's firearms were all in order. And he testified that he did that, and in fact they were. So now to attempt to draw this inference that accused number 2 knew exactly which 2 firearms to hand over is simply not the truth. Your Worship, to say, if I'd had more time, I would have charged Larry Mavundla. I actually don't want to say it again. I can't believe that my learned friend is saying that. In the further particulars, before this case proceeded, 2, 3, 4 years ago, the previous prosecutor, Elna Smith, wrote the further particulars truthfully as she could, and she did the right thing. In those further particulars, she mentions that Larry Mavundla had been issued with that firearm, that he was in East London on the night in question, and that it alleged that his firearm was the one that had fired the cartridge case on the night in question. She made the right decision, because there is no evidence to suggest that Larry Mavundla fired any shots on the night in question. And there is no evidence to suggest that he handed it to anybody. But as we have heard from the cross-examination of the investigating officer, he was asked, why didn't you take a statement from Larry Mavundla? So he didn't want to give one. But they didn't want to use Section 205 to force him to appear before a magistrate and explain the position. His argument in that regard, with respect, has got no merit whatsoever. And then your Worship would have heard, which is so telling in this case. While he's addressing you, he says to you, the video shows, and he's about to say, accused number 1 handing the firearm to accused number 2. Then he hesitates and says, the firearm shows accused number 1 handing the... And then he realizes that it doesn't show that. Then he says, we can draw the assumption that it handed to accused number 2. You know what, I can almost go as far as to say, so what if accused number 1 handed a firearm to accused number 2? That is not the charge. The charge is that it was accused number 2 who handed the firearm to accused number 1 prior to the shooting. What my learned colleague is talking about is after the shooting. If this court can say, because there's an assumption that it appears that accused number 2 handed a firearm to accused back, it appears that accused number 1 handed the firearm back to accused number 2 after he had fired it. Therefore, I can draw the inference that it must be accused number 2 who handed to accused number 1 in the first place. Well, I'm afraid, Your Worship, that is not going to do it. Thank you.
if you were still taking instructions
Maybe my client didn't understand. Maybe I should just put it to you this way, Your Worship. It is clear from the evidence that when Janssen came to do the inspection at TSS, the evidence shows that by that time there had already been an arrangement that the firearms were going to be handed over to the police. That's
one aspect, I will say that it was out of charge, Larry Mabunta. I said I would have charged accused number 2, not Larry Mabunta. If I did say that, it must have been a slip of the tongue for changing the breech block and for changing the firing pin. Lastly, which is the issue relating to the witnesses that uses that as the tool of the trade and so on. They are not ballistic experts, so they correctly confirm that they were not able to say that whether it was indeed a real firearm or not. The importance of the evidence here is that of Colonel Guadeka, who's already mentioned. You should put regard to other issues that I was interpreted, my heads are there. Your Worship, like Colonel Guadeka correctly said, I don't feel that justifies an answer. Thank you.
Okay, that is all from anybody. Close this chapter. Okay. Of course, they don't think that it can be expected of me to simply proceed with judgment in this matter right now. I will also consult my diary, weigh the options, and then since we are, I don't know how we'll do that. We'll do it in open court, I assume. So let me just think about it. There's a lot to read. I'll give an example, and I'm not throwing anyone under the bus, but the various statements has been said. You can look in the statements, the words aren't written there. I've perused it thoroughly. Those documents were placed on this bench that day. I also have to peruse and satisfy myself with the contents of each and every document, each and every submission made by the state, Advocate Odes and Advocate Matthews. So I will look at the volume. I don't know... what is the time? I can't see. 11:30. You don't have to, I'm not going to do it today, Advocate Caesar. That is in essence what I'm saying. I just want to come back with an indication of the time frame that I require. So for that purpose, do we stand down now at until 12 for me to indicate?
No.
All right. I don't have the strength. Hey. He wants me to fall down the steps by blinding me so that I can't see the steps. It's fine. Alright. Thank you. Court will adjourn. We back on record. Resumption of RC 446 of 2020 then. Just to place on record the proposals made by the court to Advocate Odes with regards to accused one was that I could endeavor but cannot guarantee that I can proceed with the ruling on Friday. They have suggested a subsequent date which seems to suit all parties, and that being the 19th of October, due to the unavailability of some of the parties present today. It cannot take place Friday. Is that correct?
I confirm that.
Thank you. The matter then postponed to the 19th of October. Accused 1 and 2 on bail extended, warned 8:30. I would say Regional Court 1 for the judgment by court on that day. Thank you. Court will adjourn.
Claro,